Hello, I'm Simon Christian, Global Research Director at Chambers. And for today's Chambers Expert Focus video, I'm really pleased to be joined by Rathmell of Kasowitz Benson Torres. Rob represents individuals and institutions in particularly complex international litigation cases, particularly ones where there are allegations of fraud, money laundering, and other misconduct. So, Rob, with that introduction, could you maybe start by explaining a little bit more about the types of work that you handle and what makes them so complex?
Sure, and thanks very much, Simon, to you and Chambers and Partners for having me. I basically represent high net worth individuals who are in distress. And that distress can range from traditional commercial litigation, business rival type stuff, through a divorce situation or a family inheritance or other type of family financial dispute, to civil asset forfeiture and criminal cases, all the way up to sanctions and international crime situations. So really the full gamut of distressful situations. My personal practice trends towards the spicier of those situations, but I try and problem solve for high net worth individuals is how best I would summarize my practice.
So what would you say then, with that in mind, that the work that you're doing is potentially the more kind of complex, the more, potentially contentious as well. What would you say are the kind of hot button topics in that world of kind of international litigation at the minute?
I'm sure my answer is going to surprise absolutely no one watching this interview, but sanctions is really where there's a heck of a lot of work at the moment. And Simon, it's not as simple as just saying sanctions. Of course, there is a lot of sanctions work for individuals who have been sanctioned. There's also a lot of work for institutions and professional service providers to sanctioned or potentially sanctioned individuals, because they have a new and genuinely constantly evolving legal landscape to grapple with, and they need to know that they're staying on the right side of that landscape. And then there's a lot of work following from sanctions, whether it's asset forfeitures, whether it's how you can continue with commercial litigation and other forms of legal situations in a sanctions context. And there's a few common themes that arise from all of this work. The first is that I really think sanctions work is unlike a lot of other legal work. It's not like, for example, white-collar criminal work. It's, of course, very different from civil litigation. And the reason for that is that it's a completely new and different set of rules, right? The rules that govern sanctioning people, the authorities that sanction people, the standards they use to determine who gets sanctioned, the standards they use to determine who gets unsanctioned, are all completely different from the traditional legal standards of criminal law or civil law. And so there are relatively few firms and practitioners that specialize in navigating these situations. But of course, given the recent events in relation to Ukraine and Russia's invasion of Ukraine, they've become one of the hottest legal topics in the market.
So would you say that the advice is kind of as much strategic risk advice as it is necessarily always going to be kind of pure legal advice?
Yeah, that's a great way of putting it. It's you really, I mean, it sounds relatively stereotyped, but you do need a holistic solution in situations like this. We could have a debate for many hours on, if you like, the concept of sanctions and whether they're right or wrong and whether they're justified or not justified. But no one can deny the fact that sanctions are quite a blunt instrument that exists outside the traditional protections of the rule of law. There's very limited judicial oversight, for example, whether you're in the UK or the US or elsewhere, of sanctions, because sanctions by their nature, right, are an executive action. And the executive is afforded a huge degree of latitude. So let's say I am a high net worth individual from from Russia, and I am sanctioned by either the UK or the US authorities. That's very different from being charged by the UK or the US authorities with a crime, where immediately a well-trodden court process kicks in, presumptions of innocence, legal procedure, even things as basic as right to legal representation are not guaranteed and are more complex and more nuanced in a sanctions landscape. All that's quite a long way of saying that when you have a sanctions case, you're not just trying to win it in the way that you are a case in court. Of course, often an ultimate goal is to persuade the authorities that person X should not have been sanctioned or has done enough to justify being released from sanctions. But equally, that doesn't usually just involve persuading a tribunal. You have to look at wider considerations like the public profile, like the position of family members, like the position that that person holds in political or business spheres. And all that goes beyond a traditional legal practice.
And I would guess as well that it's relatively rare that you have someone who's only dealing with this in one territory or one jurisdiction at a time. So does that kind of come in as well, where you have to think about maybe the strategy needs to be thought out on a bit more of a worldwide scale compared to just winning the one battle that's in front of you each time?
Yeah, that's another great point. And definitely the cases are always global. I mean, they're always international by their very nature, right? Because you're always being sanctioned by a country that is not yours. Usually, I would agree with your point that they're dealing with multi-jurisdictional sanctions because, for example, the US, the UK, and the EU tend to be in lockstep in this. There are, however, situations where person X is sanctioned in one of those places, but not the other. A well-known example that I'm personally not working on, but it's been well publicized, is Roman Abramovich, for example, is sanctioned in Europe, but not in, for example, and in the UK, but not in the US. Right? In those types of cases, they're still multi-jurisdictional because there's a reason why person X is sanctioned in one place, not the other. And often you're liaising with the authorities in one place to try and improve your position with the authorities in another place. So for that reason, whether or not you're sanctioned in one place or everywhere, you're usually engaging in multiple places at the same time.
So what should both kind of clients and practitioners, what are the most important things that they've got to be mindful of when they're dealing with this sort of work that involves international clients, multiple jurisdictions, maybe cross-border asset holding structures as well? What should they be kind of thinking about? What should they be mindful of?
Yeah, if I may, I'll answer that in two parts. First, I'll do it specifically in relation to sanctions, since we've been talking about that for a few minutes, and then I'll do it in relation more generally to the areas in which I practice, if you like, all sort of international type high net worth litigation. In relation to sanctions, there are core differences in the ways in which sanctions are implemented in the main international places in which they're implemented. So of course you need to be very familiar with those differences. I think I mentioned a few minutes ago the right to legal representation. That, for example, is a very different issue in the US sanctions landscape than it is in the UK sanctions landscape. So even though broadly speaking, of course, the US and the UK are aligned in their sanctions landscapes, there are often very crucial distinctions in the slightly more nuanced sub-issues. And the second part in relation to sanctions is beware snake oil salesmen. One of the most common issues I face in my practice is I have a lot of people come to me who have dealt with or suffered from or been brought up in cultures and countries where it's quite common for and often quite proper, sometimes improper, sometimes proper, but quite common for a lawyer's solution to a client's problem to be, oh, I'll call the judge, or I'll call the Treasury Secretary, or whoever's in charge of implementing sanctions in that country. And as I said, in some countries it's permissible, in some countries it's just as impermissible as it is for us. But That is not a solution in the jurisdictions in which I operate, and in most Western jurisdictions, of course. Not only is it usually unlawful, it's always improper, and it's never successful, right? There just isn't a situation in which you pick up the phone and someone fixes something. Indeed, that would at best backfire to the client. So understanding how to explain that difference to people who aren't used to that is an important thing. And secondly, frankly, there's a lot of people who, notwithstanding everything I've said, promise that type of solution in the UK or the US. And it's quite a skill to be able to explain to clients without sounding like you're just trying to get the work for yourself, right? You shouldn't be listening to anybody that says they can pick up the phone to OFSI in the UK or the Treasury Secretary in the US and fix it for them, because they can't. So that's what I mean by beware snake oil salesmen in this area. And that's really born of the fact that sanctions is hard, right? It's a hard landscape because it doesn't have those traditional legal protections. So often people are forced to sort of promise the world because they're already fighting an uphill battle. More generally, Simon, in terms of the international work, of course, it goes without saying that you always need to be mindful of the differences in laws between different jurisdictions and having good and effective local counsel. That's an obvious point. Where I like to think a little deeper, though, is in the differences in legal culture between countries and the relationships between lawyers in jurisdictions and the relationship between lawyers and the courts in jurisdictions. A good example is in a lot of smaller jurisdictions, a lot of offshore jurisdictions, for example, because they're smaller and all the lawyers know each other and all the judges and lawyers know each other. There's a lot less time and patience for procedural shenanigans, for delay, for messing around in the way that it can actually be a legitimate tactic, delaying tactics in, if you like, larger jurisdictions where you have heavily adversarial things. I think it's to the credit of smaller jurisdictions that because everybody is in such a small space, because they know that, yes, today they're dealing with this big case, but tomorrow they'll probably be on the same side of a case. In 2 days' time, they'll probably be appearing in front of the judge in a sort of domestic dispute or something like that. There's just less time for gamesmanship. And in those jurisdictions, you need to respect that. And you need to understand that the type of strategy that might work in the High Court or in the Southern District of New York isn't appropriate and will backfire in those jurisdictions. To the contrary, there are some jurisdictions outside of the UK and the US where there's actually more room to play, if you like, procedural strategy, and it's a perfectly legitimate and accepted strategy. A lot of civil law countries where you have these long sort of inquisitorial style processes actually build in a lot more flexibility into the time frame that can be leveraged. So it's not just understanding the laws, and getting good local counsel to advise on that. It's getting good local counsel to really teach you the culture of law and how it operates in those places.
And would a client be advised to have somebody on their team who, maybe not their principal job, but a big aspect of their role would be that kind of strategic oversight of making sure that, you know, if they're working with 4 or 5 different firms around the world and potentially other professionals as well, forensic accountants and people like that, maybe dealing with different tribunals or different prosecuting authorities or things like that. Is there a role for a sort of strategic coordinator kind of figure within that to make sure that all of that is proceeding in a way that aligns with the strategy of the case?
Yes, absolutely. I like your phrase, strategic coordinator is much better than what I say, which is quarterback, right? Which is the same idea entirely. And it's a role that like I often end up doing, or a lawyer ends up doing, usually because there is a legal context to all of this. But it doesn't actually have to be a lawyer. It can be a trusted advisor. It usually helps if the person has a professional background. And a lawyer is a substantial advantage. but it's also important, and you know, it's important not only substantively in terms of the ability to give objective advice, but also important in sort of client relations and marketing to clients. That in my experience, at least, the quarterback lawyer is usually better placed if their firm is not the main law firm running the case, right? Because it's a tough job being the quarterback, and you need almost either hiring and firing powers, or at least advisory privileges to the client. And you know, use myself as an example. Let's imagine I'm quarterbacking a case for you, Simon, a high net worth individual dealing with disputes around the world. If I'm pushing my law firm to run the US part of that exclusively, it makes it very hard, indeed impossible, for me to do that objectively to you, because of course I owe you duties as a client, but equally I'm a partner and a fiduciary of my law firm. So in my experience, it's a role that needs to be separated from the lawyers carrying out the actual heavy lifting litigation. And I enjoy both roles, to be honest. I like, obviously, the quarterback role, and and sort of thrive in that environment. But equally, if I'm running the main US piece, it's actually comforting and adds a degree of security to know that there's another lawyer I can call who sort of gets the big picture of what's going on, and who I can have a direct conversation with, and who will then be able to, you know, advise the client not only on, frankly, what they think of my performance, but also on how what result we've achieved, good, neutral, or bad, plugs into the global strategy.
I mean, is there anything else then that we should, in the sort of couple of minutes that we've got left, is there anything else that's really, really important to kind of get across in terms of what clients and maybe other professionals should be thinking about here? I'm sure there's a huge amount, and we could probably talk for the rest of the afternoon about it, but is there anything else that's really, really important that they should be focused on?
I guess this is general, but I see it a lot in international cases, and I guess it goes back perhaps to the need for there to be sort of understanding about the different professional cultures, but communication, right? It's in every walk of life, right? Whether it's your family or your work, communication is key. But in these big international cases where you're dealing with different time zones, different ways of working, different crises blowing up at different times, having everybody in a regular channel of communication is absolutely vital. On big cases, with big teams, almost without exception, I seek to have a weekly meeting, a weekly all hands meeting. Of course, you know, we don't want to waste people's time or clients' fees, but so you don't need every lawyer everywhere in the world to join, but a representative from each of the teams joins. We go through the list. I try and have them on Mondays, Tuesdays, and circulate agendas on Fridays, right? So everyone knows what's coming up. And then, you know, regular email updates, sometimes even daily updates if the case justifies it, sometimes bi-weekly, sometimes weekly following the meeting, but regular channels of communication, because a lot of problems that I see in international cases comes from what I call siloing, and sometimes it's a human instinct of a client, frankly. Sometimes it's a bad quarterbacking job. Sometimes it's the lack of a quarterback, but you have these silos either intentionally or unintentionally. And, you know, a team in Germany is not talking to what the team in the UK is, and then wires get crossed, things get missed. And, you know, what I see a lot happens is the client's team in one country will file something with a statement of facts. And while the law is different, right, the facts have to be consistent throughout. Then there's a team in the US that's like, well, hold on, I thought the facts were different, and now I have to file something in Texas next week. But I have to change my statement of facts because it's not consistent with this, or someone has to change what's already been filed in Germany in the example we're talking about, right? So all of those things can generally be mitigated by having transparent but also regular communication.
Fantastic. Well, thanks so much, Rob, and thanks for taking the time to speak to us today. You can find out more about Rob's practice on Kasowitz.com, and you can also follow Chambers Global Practice Guides and Chambers Expert Focus on chambers.com. I hope you've enjoyed today's presentation, and I hope you have a great rest of the day. Thanks.